Hello, this is Rocco Beatrice. I'm the Managing Director for Estate Street Partners, and today I want to talk about what is the most common way that people hold their assets. Most people hold their assets as joint tenants. Husband and wife usually open up a bank account, hold real estate. It is the most common way and really is the worst way to hold any asset. When it comes to asset protection, one person gets sued, they both end up losing the assets that they hold. If they get divorced or if somebody dies, this is where you end up hearing in a divorce situation, he cleaned me out. He went into my account and took all money out. Most attorneys, this is the only way that they recommend holding assets, and they're really practicing malpractice because no one should be holding assets in their personal names. Other people hold their assets as partnerships, limited partnerships, corporations, limited liability companies, trusts, revocable and irrevocable. For real estate, the most practical way to hold real estate is not to hold it at all. It should be within a trust, because if something goes wrong, if you have children under the age of 18, you own their nuts and bolts. If they do something wrong, you're the one that has to pay. If you get sued, if you hold your property in a trust, you don't hold any assets. Therefore, you don't become party to the liability lawsuit. In some states, tenancy in common, like California, for example. In California, as a community state, it really doesn't matter who is the actual title holder between husband and wife. If the husband holds it in his name only, the wife also owns it, and vice versa. So when one party gets sued, they both get sued. Or if they end up splitting up, the common law state says that they have to divide their assets equally. In some states, tenants by the entirety is another way of holding personal assets. That means that when one dies, the other person holds it entirely. What's good about this is that you don't have to go through probate. The bad part about it is, for example, in a second marriage, is that, let's say Mr. and Mrs. Jones own a house and Mr. Jones had a prior marriage and he has some kids. Those kids are completely excluded. And that wasn't his intention. He would want to leave some money to the children. But holding it either a tenancy by the entirety or as tenants in common, that precludes, because it doesn't go to probate and it automatically goes to the spouse. For more information about how to hold your personal assets, please go to our website, ultratrust.com.